Another frequently asked question here at the law firm involves slip and fall cases. The question usually is, what is the difference in terms of where the accident happens? If my fall happens in a food store, if the fall happens at a friend's house, how does that affect the case? Well, there are three classes of people under Florida law. You're either an invitee, you're an invitee by contract, or you're a trespasser. If you're a trespasser, that means if you're cutting across a parking lot because it's a shorter distance to get from one place to the other, but you're truly doing no business on the defendant's property, and you fall because they have a large hole on their property, the duty that that owner has to you is only to warn you of any dangerous conditions that they actually know about. In other words, if that pothole happened 3 days earlier, but they didn't inspect the property from the time that the pothole was created until the time of your fall, and they didn't know it was there, and you can't prove that anyone told the landlord that it was there or the property owner, then the property owner is not going to be responsible for your fall. They will have had no duty to warn you of that condition, no duty to fix it, and no duty to do a reasonable inspection to discover it. If you're an invitee on the property, that means if you're there because you're invited to be there, then it doesn't matter whether it's a shopping mall or whether it's at your friend's house. As long as you're invited by inference, if it's in a shopping mall, if there's stores there that are selling merchandise, it's presumed that if you're there with money in your wallet and you don't have any, unless they could prove that you intended on doing something other than shopping, like you intended on robbing somebody and you had no legitimate intent to enter the property, to actually enter and shop, then you're an invitee. And as an invitee, whether it's there or whether it's in a friend's house, they do have a duty not only to warn you of dangerous conditions that they know about, but they actually have a duty to do a reasonable inspection of the property to discover things that they don't know about that might be dangerous on their property. They've got to go look for things that might be dangerous. They've got to look for them just as a reasonably prudent property owner in their situation would, and they've got to fix it or warn you about it before your accident happens, or else they're responsible.